Chapter 8. Acceptance of Bills. Section 71. Meaning of term. The acceptance of a bill of exchange is the act by which the person on whom a bill of exchange is drawn, called the drawee, assents to the request of the drawer to pay it, or, in other words, engages, or makes himself liable, to pay it when due. As stated in the Negotiable Instruments Law, the acceptance of a bill is the signification of the drawee of his assent to the order of the drawer. Section 72. Object of acceptance is. Acceptance applies only to bills of exchange, foreign and inland, for the law of presentment for acceptance and of acceptance can have no application to a negotiable contract, where, from its nature, there is or can be no acceptor. The Negotiable Instruments Law provides that a bill of itself does not operate as an assignment of the funds in the hands of the drawee available for the payment thereof, and the drawee is not liable on the bill unless and until he accepts the same. Thus the drawee of a bill is not bound as a party to the bill until he has accepted it, or agreed previously to pay it, and cannot be sued by the holder of the instrument, though he has funds in his hands sufficient to cover the bill, except where the bill constitutes an equitable assignment of the fund drawn against. So due presentment for acceptance by the holder is a condition precedent to the exercise of rights against the other parties to the instrument arising when the bill is dishonored by non-acceptance. The object of acceptance then is to bind the drawee and make him an actual and bound party to the instrument which he is not until he has accepted. For until there has been an acceptance the drawee is under no obligation whatever upon the bill itself. He may have in his possession funds belonging to the drawer, but that is a different obligation from that which appears upon the face of the instrument, and until he does accept either in writing or verbally, he is under no obligation to the parties upon the bill of exchange. Thus, the purpose of acceptance is to create liability on the part of the drawee of the bill. By accepting he agrees to pay according to the terms of the bill, that is, his contract, after he writes his acceptance or verbally makes the acceptance, is on the bill itself. Section 73. Form of acceptance. By the Negotiable Instruments Law the acceptance must be written, signed by the drawee and must contain an express or implied promise to pay in money. The provisions are as follows. The acceptance must be in writing and signed by the drawee. It must not express that the drawee will perform his promise by any other means than the payment of money. The holder of a bill presenting the same for acceptance may require that the acceptance be written on the bill, and if such request is refused, may treat the bill as dishonored. Below is a form of acceptance written on an instrument. $120 Chicago, ILL. December 1, 1908. 30 days after date. Pay to the order of John Matlock. 100 G. 20. Value received, and charge the same to account of to Donald Morris, Jonestown, N.Y. Henry Hamilton. The acceptance may be made while the bill is still incomplete, but is usually made a reasonable time after execution. The holder may require that the date of acceptance be written on the bill so it will appear from the face of the instrument when it is due. An acceptance, if in writing, is constituted by words showing an intention to accept and not putting a direct negative upon the order contained in the bill. At common law a verbal acceptance is allowed, and such is constituted by any words which evidence such intention clearly and unequivocally, if they be addressed to the drawer or holder, and he waive his right to a written acceptance. And at common law an acceptance may also be implied from conduct evidencing such intention. Acceptance by telegram has been held sufficient, and under the statute of some states, which make an unconditional promise to accept a bill before it is drawn equivalent to actual acceptance in favor of a party, who upon the faith thereof receives it for valuable consideration, it has been adjudged that a telegram written and sent by the promisor operates as an acceptance. Section 74. Nature and effect of acceptance. The drawer of a bill undertakes that when it is presented to the drawee, the latter will accept it, and by acceptance is meant an undertaking on the drawee's part to pay the bill according to its tenor. Until the bill has been accepted, the drawer is the primary debtor. After acceptance, the drawer becomes secondarily liable, and his liability is the same as that of a first endorser upon a promissory note. The effect of the acceptance of a bill is to constitute the accept to the principal debtor. The bill becomes by the acceptance very similar to a promissory note, the acceptor being the promisor, and the drawer standing in the relation of an endorser. Upon paying the bill, the acceptor can charge the amount of the same to the fund of the drawer in his hands, or if he has none, he can recover from the drawer by action. If the drawee refuses to accept the instrument after he has promised to do so, the drawer may sue on the original amount due or on the breach of his promise to accept the bill. Section 75. According to tenor of bill. The acceptance must be according to the tenor of the bill to bind all the parties to it. The promise must be to pay all the money called for in the bill, at the time and place of payment. If the acceptance were not according to the tenor of the bill, there would be 2 or 3 causes of action divided among the parties. If an acceptor of a $100 bill of exchange accepts for $50, that leaves $50 which has not been accepted. There would be confusion when the obligation was paid. The party paying would be entitled to possession of the bill, and that would raise the presumption that the whole bill was paid. So for these among other reasons, the acceptance must be according to the tenor of the bill. When the modification of the tenor of the bill is such that it either casts no hardship upon the endorser, or where the endorser or parties prior to the acceptor know of the modification and assent to it, the reason for rejecting it as a form of acceptance ceases to exist. And so the rule is that a modified or qualified acceptance, if immaterial, or if known and assented to, is a good acceptance. The negotiable instruments law provides as follows as to a qualified acceptance. The holder may refuse to take a qualified acceptance, and if he does not obtain an unqualified acceptance, he may treat the bill as dishonored by non-acceptance. Where a qualified acceptance is taken, the drawer and endorsers are discharged from a liability on the bill, unless they have expressly or impliedly authorized the holder to take a qualified acceptance, or subsequently assent thereto. When the drawer or an endorser receives notice of a qualified acceptance, he must within a reasonable time express his dissent to the holder, or he will be deemed to have assented thereto. Section 76. Delivery. The negotiable instruments law provides, acceptance means an acceptance completed by delivery or notification. This is the general rule, and to avoid confusion should be followed in all jurisdictions. Section 77. Acceptance of incomplete bill. While still incomplete, a bill may be accepted. The negotiable instruments law provides, a bill may be accepted before it has been signed by the drawer, or while otherwise incomplete, or when it is overdue, or after it has been dishonored by a previous refusal to accept, or by non-payment. But when a bill payable after sight is dishonored by non-acceptance and the drawee subsequently accepts it, the holder, in the absence of any different agreement, is entitled to have the bill accepted as of the date of the presentment. Section 78. Varieties of acceptance. In general, there are several varieties of acceptance. For convenience they may be classified as to their terms, as to their form, and as to the mode of proof. As to their terms, acceptances are either general or qualified. As to their form, they are either written or by parole. As to their mode of proof, they are either express or implied. Section 79. Varieties of acceptances. As to terms, general acceptance. An acceptance is either general or qualified. A general acceptance assents without qualification to the order of the drawer. A qualified acceptance in express terms varies the effect of the bill as drawn. An acceptance to pay at a particular place is a general acceptance unless it expressly states that the bill is to be paid there only and not elsewhere. The above sections of the negotiable instruments law, as a general rule, have been the law in this country without statutory enactment. Section 80. Varieties of acceptances. As to terms, qualified acceptance. The negotiable instruments law provides, an acceptance is qualified which is, 1. Conditional, that is to say, which makes payment by the acceptor dependent on the fulfillment of a condition therein stated. 2. Partial, that is to say, acceptance to pay part only of the amount for which the bill is drawn. 3. Local, that is to say, an acceptance to pay only at a particular place. 4. Qualified as to time. 5. The acceptance of some one or more of drawees, but not of all. The above is a clear statement of the law generally. Section 81. Varieties of acceptance. As to form, in general. As to their form, acceptances in the absence of statute are written or parole. A written acceptance, 1. May be written on the instrument, or, 2. It may be written on a separate paper, and if on a separate paper, a. It may be an acceptance as to an existing bill, or it may be, B. An acceptance as to a non-existing bill. Section 82. Varieties of acceptance, as to form, written. Take a bill of exchange. The drawee writes across the face of the bill accepted and signs his name on the bill itself. That is the first form. Now, take the second form of written acceptances. A writes B that he has drawn on him for $500 and wants to know whether he will accept that, and B writes to A, or to the casts no hardship upon the endorser, or where the endorser or parties prior to the acceptor know of the modification and assent to it, that the reason for rejecting it as a form of acceptance ceases to exist, and so the rule is that a modified or qualified acceptance, if immaterial, or if known and assented to, is a good acceptance. The negotiable instruments law provides as follows as to a qualified acceptance. The holder may refuse to take a qualified acceptance, and if he does not obtain an unqualified acceptance, he may treat the bill as dishonored by non-acceptance. Where a qualified acceptance is taken, the drawer and endorsers are discharged from a liability on the bill, unless they have expressly or impliedly authorized the holder to take a qualified acceptance, or subsequently assent thereto. When the drawer or an endorser receives notice of a qualified acceptance, he must within a reasonable time express his dissent to the holder, or he will be deemed to have assented thereto. Section 76. Delivery. The negotiable instruments law provides, acceptance means an acceptance completed by delivery or notification. This is the general rule, and to avoid confusion should be followed in all jurisdictions. Section 77. Acceptance of incomplete bill. While still incomplete, a bill may be accepted. The negotiable instruments law provides, a bill may be accepted before it has been signed by the drawer, or while otherwise incomplete, or when it is overdue, or after it has been dishonored by a previous refusal to accept, or by non-payment. But when a bill payable after sight is dishonored by non-acceptance and the drawee subsequently accepts it, the holder, in the absence of any different agreement, is entitled to have the bill accepted as of the date of the presentment. Section 78. Varieties of acceptance. In general, there are several varieties of acceptance. For convenience they may be classified as to their terms, as to their form, and as to the mode of proof. As to their terms, acceptances are either general or qualified. As to their form, they are either written or by parole. As to their mode of proof, they are either express or implied. Section 79. Varieties of acceptances. As to terms, general acceptance. An acceptance is either general or qualified. A general acceptance assents without qualification to the order of the drawer. A qualified acceptance in express terms varies the effect of the bill as drawn. An acceptance to pay at a particular place is a general acceptance unless it expressly states that the bill is to be paid there only and not elsewhere. The above sections of the negotiable instruments law, as a general rule, have been the law in this country without statutory enactment. Section 80. Varieties of acceptances. As to terms, qualified acceptance. The negotiable instruments law provides, an acceptance is qualified which is, 1. Conditional, that is to say, which makes payment by the acceptor dependent on the fulfillment of a condition therein stated. 2. Partial, that is to say, acceptance to pay part only of the amount for which the bill is drawn. 3. Local, that is to say, an acceptance to pay only at a particular place. 4. Qualified as to time. 5. The acceptance of some one or more of drawees, but not of all. The above is a clear statement of the law generally. Section 81. Varieties of acceptance as to form. In general, as to their form, acceptances in the absence of statute are written or parole. A written acceptance, 1. may be written on the instrument, or, 2. it may be written on a separate paper, and if on a separate paper, A, it may be an acceptance as to an existing bill, or it may be, B, an acceptance as to a non-existing bill. Section 82. Varieties of acceptance, as to form written. Take a bill of exchange. The drawee writes across the face of the bill accepted and signs his name on the bill itself. That is the first form. Now, take the second form of written acceptances. A writes B that he has drawn on him for $500 and wants to know whether he will accept that, and B writes to A, or to the payee C, yes, I will accept that bill. That is an acceptance of an existing bill. Now, suppose A writes to B and says, I in the future, I'm going to draw on you and want to know if you are going to accept it, and B writes A and says he will accept it. That is the acceptance of a non-existing bill. As to the existing bill, the negotiable instruments law provides, where an acceptance is written on a paper other than the bill itself, it does not bind the acceptor, except in favor of a person to whom it was shown and who, on the faith thereof, receives the bill for value. For example, a certain instrument has been drawn and A holds the instrument, it has been drawn upon B, and A writes to B a letter and says a certain instrument has been drawn upon him and describes it in definite terms or reasonably so, and then B writes back and states in his letter that he accepts that bill which has been drawn upon him and that he will pay it. Then A holds this instrument, he also holds the letter, he shows them to X and X says, I will take that instrument upon the promise of B that he will accept it. I see that he has written that he would and has clearly described the bill of exchange, and I will receive it. Such an acceptance is valid and conforms with the requirements. Thus the acceptance may be on a separate paper, but the promise must be clear and unequivocal. As to the non-existing bill, the negotiable instruments law provides, an unconditional promise in writing to accept a bill before it is drawn is deemed an actual acceptance in favor of every person who, upon the faith thereof, receives the bill for value. If the bill is not in existence, for the convenience of business, the acceptance may be on a separate paper. The requirements are, 1. That the contemplated drawee shall describe the bill to be drawn, and promise to accept it. 2. That the bill shall be drawn in a reasonable time after such promise is written, and 3. That the holder shall take the bill upon the credit of the promise. Thus A says to B, I am going to draw upon you for $500 and I want to know if you will accept the instrument, if I draw upon you, and B writes back a letter and says, I will accept that instrument for $500. And describes the instrument so it can be understood. A shows this letter to Y and Y says, yes, I see you have drawn that instrument as you said you would and I will take the instrument, relying upon B's written promise. Such an acceptance is valid and conforms with the requirements. The last principles also apply to acceptances on a separate paper whether the bill is or is not in existence. That is, 1. Credit must be given to the promise. 2. The bill must be described and the terms must be definite, or reasonably so, and 3. The bill must have been discounted upon the promise. But the promise is exempted if not made with the knowledge of some holder of the bill. An acceptance on a separate piece of paper is a valid acceptance mainly because it assists in the negotiating of bills. Section 83. Varieties of acceptances. As to form. Parole. A parole acceptance is not recognized by the negotiable instruments law. In the absence of a statutory intervention, it is the common law rule that an unequivocal parole promise to accept a specific existing bill is binding, but such a promise to accept a future bill, even though the bill be taken by the holder upon the faith and credit of such promise, is not binding as an acceptance. Thus where A calls up B over the telephone and says, B, I am going to draw a certain bill of exchange upon you and I want to know if you will accept it, and B says, yes, I will accept it, and A draws the bill and takes it to Z and tells him what was said by B, and Z takes it, and Z doesn't wish to rely on the credit of A because A has no credit, but takes it because of B's credit. The law generally is that such a promise is not a good acceptance of a bill not in existence, if made by parole. Section 84. Varieties of acceptances. As to mode of proof. Express. An express acceptance is an acceptance written upon the face of the instrument. Section 85. Varieties of acceptances. As to mode of proof. Implied. An implied acceptance is any act which clearly indicates an intention to comply with the request of the drawer, or any conduct of the drawee from which the holder is justified in drawing the conclusion that the drawee intended to accept the bill, and intended to be so understood. The negotiable instruments law provides, where a drawee to whom a bill is delivered for acceptance destroys the same, or refuses within 24 hours after such delivery, or within such period as the holder may allow, to return the bill accepted or non-accepted to the holder, he will be deemed to have accepted the same. Section 86. Acceptance of bills drawn in sets. The law as to the acceptance of bills drawn in sets is set out in the negotiable instruments law as follows. The acceptance may be written on any part, and it must be written on one part only. If the drawee accepts more than one part, and such accepted parts are negotiated to different holders in due course, he is liable on every such part as if it were a separate bill. Section 87. Revocation of acceptance. The acceptor or drawee who has not communicated his acceptance or the accepted bill to the holder, may revoke an acceptance before delivery and cancel the written acceptance. Section 88. What bills must be presented for acceptance? The Negotiable Instruments Law provides, presentment for acceptance must be made. 1. Where the bill is payable after sight or in any other case where presentment for acceptance is necessary in order to fix the maturity of the instrument. 2. Where the bill expressly stipulates that it shall be presented for acceptance. Or 3. Where the bill is drawn payable elsewhere than at the residence or place of business of the drawee. In no other case is presentment for acceptance necessary in order to render any party to the bill liable. Bills payable on demand or at sight without grace, or payable at a certain number of days after date, or after any other certain event, or payable on a certain day, need not be presented for acceptance at all, but only for payment. But it is usual and best, when the bill is payable at a future day, to present it for acceptance, in order to ascertain whether it will certainly be honored, and to procure the assurance of liability of the acceptor. Bills payable at sight or at so many days after sight, or after demand, or after any other event not absolutely fixed must be presented to the drawee for acceptance and payment, or for acceptance only, without unreasonable delay, or the drawers and endorsers will be discharged, for they have an interest in having the bills accepted immediately in order to shorten the time of payment, and thus put a limit to the period of their liability and also to enable them to protect themselves by other means before it is too late, if the bill is not accepted and paid within their time originally contemplated by them. Section 89. By and to whom presentment should be made. Any person in possession of a bill of exchange may present it for acceptance, or may do so through his properly authorized agent. The presentment must be made to the drawee personally or to some person who has authority to accept or refuse to accept for him. The Negotiable Instruments Law provides, where a bill is addressed to two or more drawees who are not partners, presentment must be made to them all, unless one has authority to accept or refuse acceptance for all, in which case presentment may be made to him only. Where the drawee is dead, presentment may be made to his personal representative. Where the drawee has been adjudged a bankrupt or an insolvent, or has made an assignment for the benefit of creditors, presentment may be made to him or to his trustee or assignee. Section 90. Time of presentment. The Negotiable Instruments Law provides, presentment for acceptance must be made by or on behalf of the holder at a reasonable hour on a business day, and before the bill is overdue, to the drawee or some person authorized to accept or refuse acceptance on his behalf. The time within which the holder must present a bill for acceptance which requires such presentment, is usually stated to be a reasonable time, and this is a mixed question of law and fact depending upon the circumstances. Presentment should be made during usual and reasonable hours. What constitutes reasonable hours of business depends upon the custom of the particular place and also upon the trade or business. Any hour before the customary hour of retiring will be sufficient when presented at drawee's residence. The Negotiable Instruments Law further provides, the drawee is allowed 24 hours after presentment in which to decide whether or not he will accept the bill, but the acceptance if given dates as of the day of presentation. There may be an acceptance after there has been a refusal to accept or after protest or after dishonor. So when we say it must be in a reasonable time, that means when the instrument is first presented for acceptance. It does not mean that after 24 hours the bill can never be accepted. If it is not accepted in 24 hours, the presumption arises that it will not be accepted. Section 91. Place of presentment. The presentment for acceptance, if the bill is addressed to the drawee at a particular place, should be made at that place. If the bill is not addressed to any particular place, presentment should be made either to the drawee personally, or at his dwelling or place of business at the times of presentment. Section 92. Presentment excused. Presentment for acceptance is excused and a bill may be treated as dishonored by non-acceptance in either of the following cases: 1. Where the drawee is dead or has absconded, or is a fictitious person or a person not having capacity to contract by bill. 2. Where, after the exercise of reasonable diligence, presentment cannot be made. 3. Where, although presentment has been irregular, acceptance has been refused on some other ground, presentment for acceptance is excused and the bill should be protested as dishonored by non-acceptance, when the drawee is discovered to be a fictitious person, or is incapable of making a valid contract from legal disabilities, or where, after reasonable diligence to ascertain the drawee, the presentment cannot be effected, or under any other like circumstances. Section 93. Acceptances for honor, or supra-protest. The Negotiable Instruments Law provides, where a bill of exchange has been protested for dishonor by non-acceptance or protested for better security and is not overdue, any person not being a party already liable thereon may, with the consent of the holder, intervene and accept the bill supra-protest for the honor of any party liable thereon or for the honor of the person for whose account the bill is drawn. The acceptance for honor may be for part only of the sum for which the bill is drawn, and where there has been an acceptance for honor for one party, there may be a further acceptance by a different person for the honor of another party. An acceptance for honor, supra-protest, must be in writing and indicate that it is an acceptance for honor, and must be signed by the acceptor for honor. Where an acceptance for honor does not expressly state for whose honor it is made, it is deemed to be an acceptance for the honor of the draw. The acceptor for honor is liable to the holder and to all parties to the bill subsequent to the party for whose honor he has accepted. This is a peculiar kind of acceptance. It most frequently happens when the original drawee refuses to accept the bill, in which case a stranger may accept the bill for the honor of someone of the parties thereto, which acceptance will inure to the benefit of all the parties subsequent to him for whose honor it was accepted. It is essential that the acceptor for honor appear before a notary public and declare that he accepts the protested bill in honor of the drawer or endorser, as the case may be, and that he will pay it at the appointed time. An acceptance for honor, then, is properly made by the acceptor appearing before a notary public and declaring his intention to accept for the honor of someone or more of the parties and subscribing to some such expression of his intention as accepted for the honor of A. This is done to save the credit of the parties to the instrument, or some party to it, as the drawer, drawee, or endorser, or somebody else. Someone desires to save the credit of someone on the bill, and he does so by writing accepted on the bill. The court holds that the consideration is presumed, and the presumption is that he does have funds or money. The acceptor for honor by such acceptance engages that he will on due presentment pay the bill according to the terms of his acceptance, provided it shall not have been paid by the drawee, and provided that it shall have been duly presented for payment and protested for non-payment and notice of dishonor given to him. The undertaking of the acceptor for honor is not an absolute engagement to pay at all events, but only a collateral and conditional engagement to pay, if the drawee does not. The result of this rule is to require that the bill be presented to the drawee named therein at its maturity for payment, and if payment is refused that it be protested and notice of dishonor given to him. And the rule has been stated that the acceptor of a bill for the honor of the draw cannot maintain an action thereon against him, without proof of its presentment to the drawee and non-acceptance or non-payment by him, and notice thereof to the drawer. The following miscellaneous provisions relating to acceptances for honor are found in the Negotiable Instruments Law. Where a bill payable after sight is accepted for honor, its maturity is calculated from the date of the noting for non-acceptance and not from the date of the acceptance for honor. When a dishonored bill has been accepted for honor, supra-protest, or contains a reference in case of need, it must be protested for non-payment before it is presented for payment to the acceptor for honor or reference in case of need. Presentment for payment to the acceptor for honor must be made as follows. 1. If it is to be presented in the place where the protest for non-payment was made, it must be presented not later than the day following its maturity. 2. If it is presented in some other place than the place where it was protested, then it must be forwarded within the time specified in Section 175. The provisions of Section 141 apply where there is delay in making presentment to the acceptor for honor or referee in case of need. When the bill is dishonored by the acceptor for honor, it must be protested for non-payment by him,